Sally's going to give us an update. So Sally Wainwright is going to give us an update on the Supreme Court hearing.
So I'm going to talk a bit about the Supreme Court case, which happened this week, as I'm sure a lot of you know. And I know some of you will know some of what I say, but I'm assuming not everybody does. So I'm going to try and give a bit of background. And then there's a bit that's quite technical and legal in the middle, just to try and explain some things. And then I'm going to tell you about the best bits, what I consider to be the best bits anyway. So the background is that in 2018, the Scottish Government introduced something called the Gender Representation on Public Boards Scotland Act, which at the time we all thought, oh, that's marvellous. You know, they want to make sure that 50% of non-executive directors on any public board are women. We can all support that. Until we saw that in the legislation, it said that a woman was anyone with the protected characteristic of gender reassignment. That's a British term. It basically means self-ID. So obviously we weren't very chuffed about that. And it's relevant that this was an example of positive discrimination, and it'll become apparent when I speak about why it's important that that meant that that provision was covered by the Equality Act, that the Act itself was covered by the Equality Act. However, the definition of a woman, any man who self-ID'd as a woman, was successfully challenged in court, or at least it was initially unsuccessful, but it was then successfully appealed by For Women Scotland, and that provision of the Act was nullified. We thought, well, that's great. Now we can just go back to having women on public boards. And 3 days after the judgment was issued, the Scottish Government issued revised guidance on the Act, which said that a woman is defined by the Equality Act, which defines a woman as a female of any age, but also any man with a gender recognition certificate. So we were back to having men, not quite as many men as before, but nevertheless men, being counted as women. And when the Scottish Government introduced this, I think it's really significant, they were still hoping to introduce their self-ID bill. So at that point, it would have gone back to meaning any man. So For Women Scotland challenged that in court and lost. They took it to appeal and they lost again. And last week, it went to the Supreme Court, which is the UK's highest court, who will make a definitive ruling on what the definition of a woman is, in case anybody isn't sure what a woman is.
Court case really relates to the interaction between two pieces of of UK-wide legislation, the Gender Recognition Act and the Equality Act. And the question to be decided boils down to, does possession of a gender recognition certificate change someone's sex for the purposes specifically of the Equality Act? And this is the bit which is a bit technical, so bear with me and then we'll move on from it quite quickly, I promise you. Section 9.1 of the GRA says, where a full gender recognition certificate is issued to a person, the person's gender becomes, and this is the key bit, for all purposes, the acquired gender. So that if the acquired gender is the male gender, the person's sex becomes that of a man. And you note the confusion there between the terms sex and gender, which I think was probably put into the Act deliberately at the time. And vice versa, obviously, if a woman gets a gender recognition certificate, her gender became male for all purposes. However, the Gender Recognition Act also says, subsection 1, the bit we've just talked about, is subject to provision made by this Act or any other enactment or any subordinate legislation. What that basically means is section 9.1, making a gender recognition certificate mean that you changed sex or gender for all purposes, is subject to other legislation. And the problem is, what is the default position if an act doesn't say that it is or isn't subject to the Gender Recognition Act? And this was a lot of the discussion. I mean, there was 2 full days of argument in court, and a lot of it was about case law and what cases proved or didn't prove in relation to this. Does another act have to say it isn't subject to the GRA, or can the intention of the act or be established by considering its purpose? So in other words, can we examine the detail of the Equality Act and from that conclude whether or not it intended the GRA to apply to it? So if the Scottish Government is right, and that hopefully is the worst of the legal bit over. If the Scottish government is right, a woman is a female who does not possess a gender recognition certificate, or rather, and in their view, a man with a gender recognition certificate. So you now have two different sexes counted as a woman. In court, they were calling them natal females and natal males too. The terminology got really, really confusing. And if you watch, I'm going to put up some links later. If you watch particularly the first day, you'll see just how confusing the terminology becomes when you have to talk about natal males with gender recognition certificates and natal females without gender recognition certificates. Nobody could follow it. So anyway, a female who does not possess a gender recognition certificate, or a male with a gender recognition certificate, and he gains all the rights and privileges of being a woman in law if the Scottish government is right. That means that he would have unfettered right to go into women's single-sex spaces, he would have the right to apply for women-only jobs, and he would have the right to join women-only and lesbian-only clubs and associations. And this last point becomes very important, as you'll hear, I hope. So a man is a male person who does not possess a GRC. Well, that's just a man, as you probably understand. Or a female with a GRC. So that means that if any of you go out and get yourself a GRC, you are legally a man, and you will lose all protection as a woman under the Equality Act. And the Equality Act is basically the act which gives us all our protections as women and as lesbians, or on the basis of sexual orientation. Some of you will know there's 9 protected characteristics in the Equality Act, and the 3 that are really relevant here are the protected characteristic of sex, which is the one that's really being debated. What sex is somebody? You can only have your sex protected if you know what sex you are. Sexual orientation. So again, lesbians, or indeed gay men, everything I say about lesbians applies equally the other way around to gay men. And gender reassignment, which is, for those of you who aren't from the UK, the closest you could get to it is self-ID. It's not exactly the same, but it's a British term, but it effectively means anybody who says that they are going to transition. So that's sort of self-ID. And so a female with a gender recognition certificate would lose all her protections as a woman under the Equality Act, including the loss of maternity and pregnancy protections, because that actually is another protected characteristic in the Equality Act. And indeed, there are a lot of other pieces of legislation which apply to maternity and pregnancy as well. And well, I'll come on to this in a minute, but all of them talk about a pregnant woman. So that's very important. Conversely, a woman who has a gender recognition certificate and is therefore, if the Scottish government is right, legally a man, can become pregnant if the hormones haven't interfered. And so a pregnant man, about which there was much discussion during the court case, is a pregnant woman, what you and I would know as a pregnant woman who has a gender recognition certificate. And as I say, this is one of the issues I think that the case is going to turn on, in my opinion. So a lesbian, if the Scottish government is right, a lesbian is a same-sex attracted female who does not possess a gender recognition certificate, because if I, as a lesbian, acquire a gender recognition certificate, then I become a man. So obviously, if I'm a man, I can't be a lesbian. In fact, what I would be counted as, according to the Scottish government, and a lot of this was actually said in open court by the Scottish government barrister, if I have a gender recognition certificate, then legally, if the Scottish government is right, I will become a heterosexual man. I look like a heterosexual man, don't I? You can all tell. And you can understand without me explaining why I put conversion therapy alert here, because, you know, this is absolutely central to the conversion therapy idea that we're going to, which wasn't actually discussed as part of the court case, but just as an aside, you know, one of the main things about conversion therapy is it takes it takes lesbian women or gay men and turns them into heterosexual members of the opposite sex. Ridiculous. So a lesbian is a same-sex attracted female who doesn't possess a GRC, like myself, or a heterosexual male with a gender recognition certificate. And it was really quite entertaining to listen to the Scottish Government's barrister spelling this out very solemnly and explaining how this would be the legal case. And you'll see that I've kind of put a star next to same sex, because a same-sex attracted female by this definition would be somebody who is attracted to males with a gender recognition certificate, because they become the same sex as me. Yeah, I know, it's bonkers. I mean, someday somebody's going to write a comedy about it.
I think it's already written.
I think it is already written. So clearly there are some difficulties in all of this, as you might realize. So actually somebody did a brilliant tweet the other day that said there's actually I can't remember who it was, I'm sorry, but there was 4 classes of lesbians, the 2 that I've just mentioned here, but also a heterosexual woman whose husband acquires a GRC and therefore becomes a woman and therefore forces her into a so-called lesbian relationship, and 2 gay men who both have gender recognition certificates and therefore become into a gay lesbian relationship. So that is the absurdity of UK law, if the Scottish Government is right, that is. So lesbian associations, there's particular provision in the Equality Act about associations, and I'm not going to go into it. You can read it, or you can watch the court case, because it explains quite a lot. But basically, the bit that we're really concerned about is that lesbian associations of more than 25 people, more than 25 lesbians, could not exclude males with a gender recognition certificate, because you might know that there are exceptions, so that single-sex spaces, for example, I don't know, rape crisis centres, which is ironic given that I'm from Edinburgh, rape crisis centres, for example, can exclude any men, whether or not they've got a GRC or if they self-ID, on if it's proportionate and reasonable to do so. But that doesn't apply to associations of over 25 people. So if we start a lesbian association of over 25 people, we cannot exclude men with a GRC who, as we've seen, now count as lesbians, lesbian women, indeed. It was quite interesting when the barrister was speaking about this. Periodically, she talked about lesbians being attracted to she talked about lesbian women, almost as if she knew what a woman really was. The judges, and this is now I'm getting on, you'll see I've put some nice smiley faces, because these 2 issues that I've just raised with you, I think played out very well for us in court. Because on the first day, if anybody was watching the court case, on the first day, there was some concern that well, a lot of people are like, the judges don't really get it, do they? And it was partly because, you know, some of the terminology, as I've mentioned, was very, very confusing. By the second day, I don't know whether they kind of just let it sink in overnight, because it is bonkers. You know, if you haven't really come across this stuff before, it is absolutely bonkers. And so you have to, you know, have some sympathy with people who don't immediately grasp it. I mean, maybe they did grasp it, and it's also their job to question anything that's being said to them, because they've got to probe down. So obviously on the first day, our side was giving evidence. So obviously they were asking questions that, you know, kind of pushed against that. And on the second day, it was the other way around. So a whole combination of reasons. Now, I have always said that the lesbian question, if you like, is absolutely central to this issue of sex and gender and women's rights, and that I don't think it's been given nearly enough prominence in any of the debates. I mean, basically, we're largely absent and invisible from a lot of the discussions that have ever happened before. So, I mean, I and every other lesbian, I suppose, has some responsibility for that. But this was a fantastic opportunity. It suddenly presented itself to introduce the whole issue of lesbianism at the highest level. And I initiated a lesbian intervention into this court case. So what that means is, if there's a court case like this, which was between Scottish ministers and for Women Scotland, but other parties can ask to address the court and ask to make a submission to the court. And a lot of organisations did, including a group of organisations that I basically coordinated, known collectively as the Lesbian Interveners. And unfortunately, and I think mistakenly, we weren't given an opportunity by the court to speak. Our barrister wasn't given permission to speak, but we were given permission to make a written submission. Not all the people who are asked to intervene are given permission. So, you know, but we had expected we would, because what we had to say was quite new. But by the same token, I'd hoped that because what we had to say was completely new to the court, we would be given permission to speak. And I was very concerned at the end of the first day that because the lesbian issue hadn't really been addressed by anybody who was speaking on the first day, that the question of lesbian rights in all this would not be fully addressed. But actually, I'm very happy to say that it really was. Partly, I think, because the judges had clearly read our submission quite carefully. And also the Scottish Government barrister recognised that there were two really difficult issues. I mean, she made a long submission, and towards the end of it, she said, there's two difficulties that I need to address. And one of them is the question of lesbian associations, and the other one is the question of pregnant men, which is partly why I've focused on them. And the judges, one judge in particular, who was clearly very interested in this issue, but actually several of them, became very clear that a man with a gender recognition certificate is to be treated as a lesbian, but a trans woman, as they called him, without a gender recognition certificate. This was the Lord Reid, who is the president of the Supreme Court. So he's the highest judge, the most senior judge in the UK, who was the chair of this panel. And amongst the other members of the court was his deputy. So they had the two most senior judges in Scotland sitting in the UK sitting on this case, which I think shows just how important it's seen as. And so this is a quote from Lord Reid. He said, you know, a man with a GRC is to be treated as a lesbian, but a trans woman without a GRC is to be treated as a heterosexual man. Yes. So the difference between them is pretty stark, because it is, because as lesbians, we can exclude the self-IDing trans women, in inverted commas, because they're heterosexual men, but we can't exclude the ones with the GRC. However, as they were very keen to point out, the judges were very keen to point out, that the only way to know which they are is for us to know whether or not they've got a gender recognition certificate. But, as Lady Simler was very keen to point out, we're not allowed to ask for a GRC, said the judges and the Scottish Government KC. I think they're mistaken. I wasn't about to jump up in court and say, oh, you're wrong, your ladyships, even if I'd been allowed to. I think they're wrong. I think we are allowed to ask for a gender recognition certificate. I think we're simply not allowed to tell anybody what it's that we know. So you're not allowed to pass on the information about a gender recognition certificate if you have that information, if you came across it in the course of your work. So if as a lesbian association and a bloke turned up and I said, have you got a GRC? I think, although I do hesitate to contradict the most senior judges in the country, and I may well be proved wrong, I think I can ask, but I can't tell anybody. But my point is that if I know that this man has a gender recognition certificate and therefore I have to let him into my lesbian association, and if everybody knows that my policy is to only let in men with a GRC, the fact of letting him in kind of speaks for itself, doesn't it? So, you know, whatever. But there was a lot of discussion about this, and it was brought up several times. It went round and round in circles, which was really, really good for us. I mean, you should have seen us on the lesbian bench going, yes. The particular judge who was very, very concerned about this was saying to the Scottish Government, but this has a chilling effect, doesn't it? And she was very concerned about the chilling effect. And she pointed out that in practice, it meant we had to let in any self-ID, any man who self-IDs. which is, I think, very good for our case, because it makes clear that we're totally discriminated against if this legislation goes through, if this legislation is held to say what the Scottish government says. The Scottish government had some interesting responses to this whole discussion. So there had been previously some discussion about perception and how you could tell whether somebody was a man or a woman, and concern about stereotyping. So one of the things she said was, well, how could you tell if it was a man, or if it was a woman, or, or male? Probably. How would you know he's not a woman? And there's a real danger of stereotyping. And the judge was saying, well, there are some males with a GRC who do retain some, I can't remember what the exact word was, but some, they do look a bit like they're still men, is what she said. I can't remember the words she used, but she was basically saying that, and we're going, duh, yes. Anyway, the other thing that the barrister said, the Scottish government barrister said, was, but anyway, even if we let these men with a gender recognition certificate into our lesbian associations, she couldn't see that there was a problem, because the fact that these men were identified as lesbians didn't mean that we, as other women, lesbians, real lesbians, she didn't say real lesbians, but I'm saying real lesbians, that we as lesbians didn't have to be attracted to them. I mean, after all, as lesbians, we're not all attracted to every other lesbian. So we just could not be attracted to these particular lesbians who happen to be men. She also said, and I quote, because it was such a wonderful quote, that a person, she meant a man, a person without a gender recognition certificate is not a lesbian because he hasn't acquired the sex of a woman. The Scottish government did, however, offer us a solution, and I was quite impressed, because it was a solution. I put in solution, I use the term loosely, a solution. She proposed it as a solution. That, as we knew from the Forstater case, at the time I was sitting immediately behind Maya, I'm going, stand up, that woman. As we knew from the Forstater case, being gender critical is a protected philosophical belief. And therefore, she proposed that what we could do if we didn't want to admit men with a gender recognition certificate was set up a gender critical lesbian association, which is fine if you happen to want to be a gender critical lesbian association. But not all lesbian associations want to be gender critical, but they still might want to have men in them. My lesbian walking group, for example, doesn't want to have men in it, but I wouldn't describe it as a gender critical organization, and it's certainly not a political organization. It doesn't campaign or anything. It just wants to be able to walk with other women. And the judge's responses were quite interesting, because on the one hand, one of them was concerned that if these lesbian associations were charities, then charities aren't allowed to be political. And a protected philosophical belief you might get away with, but if it was seen as a political belief, then you could lose your charitable status if you were propounding a political point of view. So that was one danger. And the other judge asked, well, yes, but what if lesbians don't want to do that? What if they just want to meet with other like-minded people? I felt quite happy, really, with the way that this conversation about lesbians and lesbian associations had gone, because even although we weren't allowed to speak, it seemed to me that, some at least of the key points that we had put forward were being addressed. And indeed, at one point, the president of the court said, in response to some argument, yes, but that's not what the lesbian interveners are saying, is it? They're saying such and such. So they were clearly taking seriously the points that we had made. So the second issue that I suggested to you was possibly going to be key, in my opinion, I'm not a lawyer, key in the final judgment, was their concern that pregnant men, i.e. women who are pregnant but have a GRC, would lose all maternity and pregnancy rights. And as I think I mentioned, it's not only under the Equality Act, there are pregnancy and maternity rights in various other pieces of legislation as well. But they all refer to pregnant women. A pregnant woman who, blah. who is discriminated against because of her pregnancy, that kind of language. So if you decide that the pregnant person is actually a man, then none of that legislation applies to him, which would mean, for example, a pregnant man, I'm using the term in inverted commas in case you didn't realize, a pregnant man would not be entitled to maternity leave. He would only be entitled to the, whatever it is, statutory 2 weeks or something of paternity leave, and so on and so forth. So there are very serious issues for women who become pregnant who also happen to have a gender recognition certificate. Now, in my opinion, and again, I'm not a lawyer, but I cannot imagine that Parliament, if part of this, the ruling, if I'm right in my understanding of it, I might not be, is going to be what was intended when the Equality Act was introduced. Was it intended that Section 9 that said of the Gender Recognition Act that says you change sex for all practical, all purposes? Was it intended that that would apply? Now, if applying that means that women would, females would not be entitled to maternity and pregnancy protections because of their new status as men, it's inconceivable, I think, that Parliament would ever have meant to do that. And indeed, as I understand it, there's a lot of EU law. And so some of this is going to be really relevant, I think, for our sisters in Europe, at least, because some of this comes back to EU law, which mandates a lot of pregnancy and maternity provisions. And if a pregnant man is going to be excluded from them, then that is going to have implications, I think, outside of the UK as well. That's my understanding. As I say, I'm not a lawyer, so don't take anything as gospel. The judges also asked about sex-specific illnesses. And they were saying, well, for example, cervical cancer, for example, is something that only women get. And there's legislation that says it's not discrimination if a doctor does things which are needed to deal with risks specifically affecting women. But Lord Reid was very concerned that there wouldn't be such a thing as an illness that only specifically affected women if some of the people in the category of women included some males who weren't subject to female complaints, biological complaints. Or indeed, as he said, if some of the women were actually now men, then you would no longer have these sex-specific complaints. So that was an issue. And another judge asked about access to medical procedures. For example, IVF is in vitro fertilization is only available to women. So if you were a pregnant man, and one of the judges specifically raised the case of Freddie McConnell, who you might know was the woman who went to court to be the pregnant woman who had a GRC, who went to court to be allowed to be called the father on her child's birth certificate, which she wasn't because the child's rights were seen to take precedence. But the judge said, well, supposing Freddie McConnell wanted to go and get IVF, would he, as she said, would he be entitled to do so? And there was much discussion about that. And the Scottish Government, KC, said that no, he wouldn't be able to claim discrimination on the basis of sex because, well, lots of obvious reasons that men don't need IVF. And he couldn't claim discrimination on the basis of gender reassignment either. So basically, Freddie McConnell, or somebody like Freddie McConnell, wouldn't be able to complain if they were refused access to IVF treatment. So that wouldn't mean that an IVF clinic was not allowed to provide such services, but if they refused to provide such services, there was nothing that this would-be pregnant man could do about it. She also said on other issues, such as cervical screening, that the doctor, although they wouldn't have to provide it, they would provide it as a matter of fact, which of course is correct. And it's one of the issues that doctors are concerned about, is that women are being missed off, and vice versa for men, screening for sex-specific diseases if they've got the wrong sex marker on their NHS records. And she said, she gave a funny example of, and I looked at it again because I thought I must have misremembered it. But she said, you know, they would go to the doctor with maybe a runny nose or something, and the doctor would say, is there anything else that you want to speak about? And then somehow this would lead you to needing cervical screening. So next time you have a runny nose, you know what to do. And she said, but this was all because this wouldn't be because of the person being a particular sex, i.e. in this case, a woman being a man, but as a matter of biology, that they might still require screening services. So once you started drilling down into all of this, it became quite evident that biology really does matter, which I'm sure the assembled company will find very difficult to believe. So I've just got some final points that I thought it would just be entertaining to highlight for you. The Scottish government invented the term Section 9 woman as a sort of shorthand. You know, this pregnant man, the Section 9 woman going for cervical screening, to refer to a man with a GRC. So should you ever hear anybody talk about a Section 9 woman, we're talking about a man with a GRC, or indeed you could be a Section 9 man, presumably by equally. For me personally, the most hopeful comment I thought I heard during the 2 days was when Lord Reid said we have to try to give the Equality Act an interpretation that is workable in practice. Well, that's really good, because one of the things that became crystal clear during the course of these 2 days was that if the Scottish government interpretation prevails, then the Equality Act is absolutely not workable in practice. And going back to, you know, the issues of, I said biology came into it a few times towards the end. And Lord Reid again referred to Section 7. It doesn't matter it doesn't matter exactly, but in that there's a possibility to have a genuine occupational requirement to be a man. I mean, we're all familiar with the genuine occupational requirement to be a woman, but there's also one to be a man, because the essential nature of the job called for a man, which, as he pointed out, was clearly predicated on male physiology being different from female physiology. So again, you know, we're coming to a fairly clear understanding here that you don't actually physically change sex, whatever the law might say. And on the question of pregnant men and some of the other medical issues and the difficulties that there were in coming up with solutions, I mean, the Scottish government KC did her very, very best to offer a solution, but after discussion with the judges was forced to concede that it was only a partial solution, that it wouldn't work. Whatever she was suggesting wouldn't work in all circumstances. She then said, if the court considers that the difficulties created by these provisions, the sex-specific conditions, are such that that amounts to an express disapplication of the whole of the Equality Act, Section 1(9), then, my lords and ladies, will find it in these provisions. In other words, she's kind of saying, yeah, this might not be solvable. And if it's not solvable, then you'll have to decide that Section 9(1) doesn't apply to the Equality Act. The difference between the KC, who's representing the Scottish government, and the Scottish government itself, who's instructing her, is the Scottish government can stand up in Holyrood, to the press, to any point, and spout whatever nonsense they want. But a KC is bound, and particularly when they're in front of the Supreme Court, but actually they're bound in any court to stick to the facts and to the law, and they can't just make stuff up. They can't spout Stonewall law, however much the Scottish government might like to. So when they're faced with a difficulty, they have to acknowledge the difficulty. It's part of their job, and she did her job very well. You know, people were sort of critical of her, but actually she was doing a very, very good job. You can only do the job as well as the material that you've got. And it's part of her job to acknowledge when there are problems. And I felt when she said this, you know, the court might decide that all what we've just been talking about means that Section 9(1) doesn't apply to the Equality Act. That would be 100% win for us. So on that basis, I'm quietly confident. I would only want to qualify that with in 2016, I was a member of the Scottish independence movement. I'm not anymore. At the time I was. And the night before the referendum, we had a victory party outside the Scottish Parliament. It's just as well we had it the night before, because if we'd had it the night after, we wouldn't have been able to have a victory party at all. So you should never count your chickens. But having said that, I think that we can be cautiously optimistic that the difficulties of the position put forward by the Scottish government are so great that the court may be minded. There are technical reasons why they might have to find the other way, but I'm quietly confident. And I've got some links, so I would invite anybody who possibly can. I would invite anybody who possibly can to make a contribution to their crowdfunder, because they did a fantastic job bringing this forward.